people today. They could spend half their lives over 50. That's a lot of living. So it helps to have a wise friend and fierce defender in your corner. A friend like AARP. So your health lives longer.
This is just slow-mo karate?
Just slow-mo karate.
Your money lives longer.
I just bought that.
I just sold that.
And your happiness lives longer. That's why the younger you are, the more you need AARP. Join today.
Welcome to AARP Illinois' virtual event. It's so wonderful to have you with us. AARP is on a mission to connect with individuals across various communities, especially those aged 50 and above. We're here to listen, understand, and address the unique needs of you and your community as we age. Our goal is to enrich your experience by expanding our local activities, providing opportunities for you to discover and engage with all that life has to offer right here in your own community and virtually. As we journey through today's event, we invite you to consider joining our dedicated team of AARP volunteers. It's a chance to make a meaningful impact and help us better serve those 50 plus across the nation. Connect with us and be a part of this vibrant movement toward positive change. Welcome, and let's make this event both fun and transformative.
Good morning, everyone. Welcome. This is Wills and Trust, choosing the best path for your legacy. I'm Lori Hendren. I am the Senior Associate State Director here in AARP Illinois, and we welcome all of you from across the nation and around the world that's joining us this morning, or if it's evening at your time, we welcome you. We're thrilled to be having this discussion today, and our focus is going to be on elder law with a special focus of understanding long-term care planning for seniors. If you have joined us, we do this every month with our incredible special guest, Steve Andersson. He is an elder law attorney licensed in Illinois and also a contractual lobbyist for AARP. Welcome, Steve.
Good morning, Lori. Thank you for having me.
Thank you. And I apologize, my nose is running. So for all of you that are joining us, I adore you being here. We're on Facebook and YouTube, but we are here for you to answer questions, go over your comments, and really to be able to connect with you on the questions and concerns that you have. Excuse me. So we're going to be talking a broad range, starting with discussion and planning, consultation for your family. But no, everything we talk about here, please talk to your financial advisor with elder law, financial planning, and healthcare. And keep in mind, the specifics we talk about today may vary by jurisdiction. So again, consulting with your elder law attorney, tax attorney, or financial advisor is advisable for your personalized guidance. I'm going to go to Steve, let you have our opening comments, and I'm going to get a Kleenex. Go ahead, Steve.
Well, thank you, Lori, and thank you for all of that. Yeah, I always like to start these discussions, and they really are discussions, because I would encourage you to put your questions in the chat, because it's much more fun than me just droning on if we interact with your questions. But I do like to start with two things. One is that this is not the practice of law. In other words, I'm not giving you legal advice. And the reason I'm not is that I'm licensed in the state of Illinois. But this broadcast is going to people wherever they might be. And we know from some of the signups that they're everywhere across the nation. So what I try to do is not give you any particular state's law, including Illinois, by the way. I try to give you what is basically the law in most states. So it's really kind of both the law in all states and the law in no state at all. So think about it that way, as it's a primer on these subjects. So that's number one. And number two, I always like to say that I'd love to call this show "It's Gonna Be Okay," because that's my mantra with this, and that's the mantra that I do use when I work with my clients. Is you may take a lot out of this conversation, or you might take very little out of it. It's gonna be okay, and the reason that I say that is you may act on some of these things, or maybe you want to, but you're never getting around to it. And I tell you, that happens to all of us with estate planning, especially. You know, we don't always get to it. And it's going to be okay. Why? Because most states kind of set up their default laws for what you might expect you would want to have happen with your estate. So if you fall into a fairly typical category where maybe you're married or you're a surviving spouse, you've got kids or maybe grandkids, and you want it all to flow to them, probably equally. That's what the default is. That's what most states set up for. Now, that doesn't mean your situation will be exactly right for that. And that's why we do these shows, because even though I can tell you it's going to be okay, we want to do better than okay. We want to make it good for you and your family. And that's why we talk about the things that we talk about. So with that, Lori, you ready to fire off some questions?
Yes, with it's going to be okay. Let's start our first question. Steve, what are the key differences between a will and a trust, and how do they affect estate planning?
Yep. And this is a question that is very popular. I think a lot of people hear a lot about living trusts because there's lots of different kind of trusts, but we're going to talk mostly, I think, about living trusts. So this is about how to pass your assets on to your heirs. And your heirs can be anyone you want them to be. Could be your family, but could be, anyone down the street if you felt like it. That's totally up to you. But there are two major ways to do that. One is a will. That's the most traditional way, which is you write a document that says, I, being of sound-minded body, do bequeath my assets as follows. And then it's however you want it to be. Recommend always that you use a lawyer to do that because there are some formalities with that. And that's kind of option number one. Option number two is you create a living trust. And that's a trust that kind of could reflect all the things you would say in a will, and usually does. But it comes into effect right away. It's an agreement, if you will, kind of with yourself, oddly enough, that upon your passing, the trust will distribute your assets. Now, people will ask, well, why does that matter? What is the difference there exactly? It's two documents, just two different types. And that's true. The first document, though, goes through probate, assuming you have enough assets, which, at least in the state of Illinois, it's probably, if you have more than $100,000 worth of assets, or you have a house, or you have some odd assets that maybe aren't kind of unique, you have to go through a court process called probate. The process is public. Your assets aren't really public. Those don't get shown, but a lot of things about the process and who your heirs are, that all does get shown. And not everybody loves that public aspect of it, and not everybody loves to go through a court process. That's where the living trust comes in. So if you don't enjoy those aspects and you would prefer to do it in a more private way, and sometimes a quicker way, because probate can take 6-8 months to go through, you create this trust, the living trust. And by doing so, you bypass all of that. If you do it right, there are a lot of tricks with that. But if you do it right, your assets can be distributed to your heirs fairly quickly, and it's completely private. So two different ways of doing it. Neither is right. It's whatever's right for you, because typically the living trust is expensive upfront. The probate and the will is much cheaper upfront. So it depends on when you want to spend the money. Either you can spend the money for the living trust up front, more expensive, but then it's kind of cheaper on the back end for your heirs. Or you can not spend that money up front. You can just use a will, and then the probate estate pays for the rest of it. So one way or another, it'll get done. It's just a question of your level of comfort with one or the other process.
So, why would a living trust? So, two questions. Why is a living trust more expensive up front? And then, two, if you have a living trust, can it be broken after your passing? Let's say your 15th wife came in and said, "No, I don't like the living trust you did with your second wife. We're going to break it." So, two
Sure.
questions.
Sure. So number one, if you have a 15th wife, see the attorney and make sure to update after each and every one of those, even after every one of those wives. So I'm going to answer the second question first. Anything can be challenged, okay? A probate estate can have challengers in it, but so could a trust. They both can be challenged the same way, which is you go to court and you file a complaint alleging whatever it is that you feel was done wrong or improperly. So nothing is 100%, but typically the trust is a lot easier to defend in the sense that it's been up and established for presumably a long time since you created it. Hopefully you create it and you live for a long and healthy life. You can create them at any time, by the way. You don't have to wait. You could do it when you're 30 if you felt like it. So both can be challenged, though. Now, the likelihood of challenge is less with the living trust. Like I said, there's a lawyer more heavily involved. It'll be established for a lot longer time. So there's some advantages to that. But again, it's not guaranteed. And so jumping back to the first question, why is living trust more expensive? It's more complicated. It becomes a real document, a real living document right away. You have to transfer your assets into the trust. That's more complicated. You actually start writing checks. You have to get a new checking account because the checking account shouldn't be you. Like my name's Steve Andersson, so my checking account says Steve Andersson on it. If I have a living trust, I would create a new checking account called the Living Trust of Steve Andersson. I'd be the trustee. I'd still be in control, but I'm not signing as myself anymore. So it's much more complicated, and there's a lot more that you have to keep track of, because if you don't, as you age and as you go through life, you might pick up different assets. Maybe you sell a house, buy a new house. All that has to be retitled every time you change into the living trust. So that's something, there's a lot more to keep track of. So I
Okay,
hope that,
interesting. No, that's great. So all of you that are watching and joining us today, make sure you put your questions and comments in, because we are going for a power half hour. We want to make sure we get those answered with Steve. So let me go to our next question. You talk about probate. How does it work, and how can a trust help avoid probate? I know you touched on it a little earlier, but let's walk us through a little bit more on that.
Sure. So let's talk real quickly about how the trust avoids probate again, and then I'll explain the probate process. So the trust avoids it, like I said, because it becomes a living document right away. And so because of that, you have no assets when you die, because the assets are already held in that trust. That's the reason you don't have to go through probate, in theory. And you see that I held up my finger because there's a qualifier to that. Let's say, I'll give you a dramatic example, but let's say you've done everything perfectly with your living trust. You don't want to go through probate, but unfortunately your death is the result of an accident, okay? A terrible thing, but let's say you died due to a car crash and somebody else was at fault. Well, your heirs have a right of action to seek compensation for the taking of your life. That's not in your trust, because it can't be. You can't transfer it ahead of time. It happens when you die. And as a result, even though you have that trust, it means that you probably have to go through probate as well, because you're going to have to settle that personal injury suit or try that personal injury suit. You won't have to, your heirs will. And then that money that results from that probably has to go through probate. So there's no perfect circumstance, never a perfect circumstance, but that's how that happens. So, but generally it avoids it because you have no assets upon your death. So flipping back, I seem to like going in reverse today. I don't know why. The probate process itself, upon your death, your will is filed by your heirs, probably with the help of an attorney, in the local court in the jurisdiction in which you died. So I'm here in Sangamon County, Illinois right now. So if it were here, they would file it with the Sangamon County Clerk's Office or the Circuit Clerk's Office. A probate case would be opened. It'd have a file number. There would be a number of forms to fill out, basically identifying who might be a creditor, who are your heirs, what assets you had, those sorts of things. And then the judge gives the person you designate as your executor in the will, gives that person the authority, the legal authority, to kind of commingle all your assets, get them all together, pay off any debt if there is any, and then distribute to the heirs. But there is a 6-month, at least in Illinois, I can't speak for everybody, there's a 6-month period of time where you have to wait. That's the creditor's claim period, where you don't want to distribute ahead of time, because that's the amount of time that creditors can come in and say, oh, Mr. Andersson owed me money, therefore you have to pay me first. But once that's done, so 6 months, and I always say 8 months because it usually takes a little longer than that. Once you get that all wrapped up, then the distribution can happen, and then you can close that probate estate.
Okay, so this is the best part of our segment. We have a lot of great questions, so I'm going to start. Hi, are 2 living trusts necessary for a married couple?
That's a great question.
It is good.
People do. There are things called joint living trusts. I don't recommend them. I recommend 2 living trusts, because what can happen is let's say the first of you passes away. Typically, people don't pass away together, except in that awesome movie called The Notebook, where they
Oh yeah.
next to each other. It's so romantic. I love it.
Yeah.
But absent that, most people don't pass away that way. Once you do that, that living trust that's joint becomes irrevocable. The surviving partner can't change it because it was an agreement between two people, one person who's now passed away. So you have zero flexibility after that. So you have to be 100% certain you never want to change anything. And that's not usually the case. And it's especially not the case if, for example, you want to get remarried. I mean, you can get remarried. It's not going to stop that, but it really ties up the assets. So I would recommend that you have reciprocal living trusts that are mirrored. They say the same thing, but they are separate. But that's a choice. All this is recommendations. These are choices. You could do a joint one.
Here's a great question from YouTube. Is a 401k plan included in will/trust, and do they stand alone outside of them?
Excellent question. I'm guessing the person who asked it might know the answer. The answer is they are outside of it. So they are, and I'll say it again, but I'm pretty sure it's true in all 50 states, but I'll say it's true in Illinois, but pretty sure this one's true everywhere. They are separate. So you typically, when you start your 401k or anytime, you can name beneficiaries in the document, in the plan itself. And you can name one, you can name 50, you can divide it any way you want, any percentages that you want, but it has its own self-sustaining system. So upon your death, it doesn't go through probate. It's outside of probate, doesn't go to your living trust because it doesn't need to because it's just handled outside of all of that. Now you could, if you want, you could name as your beneficiary your own estate, and then it goes through probate. Not sure why you want to do that, but there might be reasons. Or you could name your living trust and it would go through there. But the easiest way typically, unless you have a very complicated estate plan, is just to name your beneficiaries. You can mirror what's in your will or what's in your living trust right into that 401k document. And that one will go fast. You'll get that money, or your heirs will get that money very, very quickly. Another advantage, we're not talking taxes today, but you roll over the rights of that 401k retirement plan to your heirs. So they can keep it for a period at least of 10 years as a tax-deferred account. So there are some advantages to not running it through your living will or your probate estate as well. But I'm not a tax attorney, so I just pretend. But
Impressive.
I would recommend if you're considering that, talk to somebody about that because it's a really great advantage for your heirs.
This is why we talk about these things, especially with financial planning and long-term planning. It really does benefit to have that expertise, and that's just someone who has that the education, the years of experience to help you get the answers you look for. Great question. If your husband dies and owes money, let's say on credit card, and the credit card's only in him, monies have been separate and have been for 35 years, would I have to pay his bills? So bills only under his name, aka credit card, aka a car note, aka a house.
Right. So in theory, you should not have to. In other words, if we'll use the credit card as the example. I'm married, I have a wife, so I have a credit card in my name only. So when I pass away, if our assets are separate, not commingled, in theory, then no, you, the surviving spouse, my wife, and that in our example, would not have to pay that. They are out of luck. However, my wife and my assets are not separate. We have most of our assets are commingled in one form or another, joint bank accounts, things like that. And so my assets, which are her assets, would be liable for that. Now, would her 401k be liable for it? No, but our joint checking account would be. So you can avoid that, but it would have to be that you've really segregated your assets.
Would you have to segregate like your savings and your checking, and like everything would have to be separate?
Mostly because what you're trying to do is you're trying to say that in our example, I died with no asset that I had no access to my wife's assets. That's the deal. Because if I have access to it, that means my credit card company probably has access to it.
Okay.
So the idea is to segregate there. It's tough to do, but if that's something that's important because of, let's say, unequal debt situations,
Medical
it might
debt.
be valuable again to talk to somebody about strategies. That might even justify a reason for one of you to have a living trust and not the other.
That's a
So,
good point. All right. Facebook, does a vehicle have to be specifically titled to the trust?
yes, it does. That's an easy question. If you don't title it, it's not in the trust. So you have to retitle your cars, you have to retitle your house, you have to
Really?
retitle whatever. Yes.
And it has to retitle to that trust name.
Yep. So
So,
now instead of
the
your
Lori
car,
Hendren Fun Time Trust, that's what it would have to be if that's what I creatively named it. Wow.
yep, yep,
So
correct.
that incurs that initial cost.
It does. Well, there'd be a little cost with the secretary here in Illinois. Titles are through the Secretary of State, so you'd have to get a new title for it. It's not terribly expensive, but it's a
Yeah.
little. It's mostly a hassle,
Right.
and that's the thing is that a lot you have to be careful because now the title to a car is not typically that, or the cars are not typically that valuable. So you could get away with not doing that because we have a thing in Illinois called a small estate affidavit. And that's where I was talking about that $100,000 value. So even if you put most of your things into a living trust, but you leave some stuff out, like a car, you could pass that via a small estate affidavit and still avoid probate. So there are that's again, one of those kind of catch-alls, right? Those defaults I keep talking about because it's going to be okay. Let's say you're not perfect with getting everything into your living trust. It's going to be okay because if it's just, less than $100,000 worth of stuff, it'll be all right.
Okay. How do we go about setting up an LT? How much does it cost? And do children have to pay taxes on everything if our house is in a LT, living trust?
In a living trust.
Mm-hmm.
So the living trust does not affect tax planning. So now typically you don't pay much, your children don't usually pay much in estate taxes. If you're in kind of the middle class world, because the exemptions, the threshold for paying actual death taxes, we sometimes refer to them, is about $1 million per person. So if you and your wife, that's 2 million. So most of the time, there's very little estate taxes that are incurred. But if there are, if your estate is that valuable, the living trust isn't going to change that. It's not going to make it worse, but it's not going to make it better either. Now, there are advanced planning techniques that you can use in the tax world. That's a little bit beyond the scope of this conversation, but they do exist. Now, there is one category where you would pay taxes, but it's very minimal, is the time period it takes to process your estate. So the living trust, like I said, very quick. And so there'd be virtually no taxes. But like I said, with the probate estate, that can take 9 months, maybe it takes a year. Well, if those assets are sitting in accounts and they grow during that period of time, you would be liable for the growth, the interest on the growth. So it's not usually very much, but it does mean, by the way, that you still have to file estate tax returns. So you need not just a lawyer, but you need an accountant or tax preparer to help you with that to make sure you don't get a letter from the IRS saying, hey, you didn't pay this. So.
Okay. As with the 401k, are any other accounts with designated beneficiary insurance, IRAs, et cetera, also outside of trust or wills?
Yes, they are. So anything with a designated beneficiary, the person asked the question exactly right. If there's the ability to do that, so maybe a payable on death account, even in a bank account, they have those sorts of things, or a joint account. We didn't talk about that. If I have a joint account with my wife, or heck, let's not use my wife. Let's say I have a joint account with a friend, right? And I pass away. My interest in that account disappears, right? So that passes automatically to the survivor. And again, anything with a designated beneficiary is outside the probate estate and also outside of the living trust. So a lot of people do use that as a mechanism, as long as you're comfortable, and you keep up with it. So as your life changes, like you don't want your 401k to list your wife Well, you probably do to begin with, but let's say you do, she passes away and you don't have any other beneficiaries on there and you didn't update it. If that happens, now it's going to your probate estate because there's no beneficiary listed.
Okay.
So the thing about the trust, if you take away anything from this conversation, is the thing about the trust is you have to keep up with it. The probate estate, not so much, but the living trust, you have to pay attention.
Interesting. Great question. Should you put both your son and daughter-in-law's names as beneficiaries on your trust?
You cut out there on your.
Oh, on your trust.
Well, number one, you have to decide. So your beneficiaries in your living trust are whomever you want. So if you want your wife or husband, you got to name them. If you want your children, you got to name them. But if you don't, then you don't name them. Some people, and this doesn't happen often, but it does happen where they specifically don't want to pass their assets to their children. Oftentimes they'll mention that in the trust or the will and say, I'm specifically not making provision for so-and-so. And sometimes they'll say why. Mostly they don't, because you don't need to. But whomever you want to receive your money, you need to list. You need to say. And how much, like what percentage. You could actually say, I want to give, $20,000 to said person. But most of the time, it's done in percentages.
Okay. Which probably, I think you've talked about this before, percentages is a better approach because at the end of your life, you don't know where your money is. And so the percentage would probably be a better reflection of what your original desires are.
Typically, yes, because, let's say you wanted to leave somebody specifically $20,000, but then you have a bunch more money. And so you want to leave that's like a gift to a friend, let's say, but then you said 50-50 to your son and your daughter, right? What happens if upon your death, you've expended all of your money and you have $18,000 left? Guess what? Your friend gets 18, your children get 0. But instead, if you put those in the term of percentages, they each would have gotten the percentages you intended, even if it's of a smaller amount.
Okay. If a mortgage in both names, would creditors be able to come after a wife for payment on a husband's death?
If the mortgage is in both of your names, the answer is yes. You are called jointly and severably liable, which means upon the death of one or even the disappearance of one, both of you are 100% liable for that debt. It doesn't mean it's double. I just mean that if it's a $50,000 mortgage or something like that, you don't each owe 25, you each owe 50. And if they can only find one of you, they're going to still ask for all 50 from one of you.
Okay. All right. Well, we have come to the end of our half hour. Again, I want to thank you all for your questions. And if we have not been able to elevate them, come back next month. We're going to be doing this every month for the entire year with Steve. Any closing thoughts, Steve, as you have just powered your way through many, many questions, and we thank you for that. Any closing thoughts for our audience today?
Well, number one, thank you very much for letting me do this. This is so much fun. It's the highlight of my month to be able to power through these questions. And I love the questions, friends. You really ask great ones. And I feel like we learn much more together by hearing because I suspect they all have real life implications for you. And I love being able to do that. And I think everybody learns from questions that other people have asked. So I just want to say thank you. And I look forward, hopefully, to seeing you all in another month.
That's wonderful. And Steve would say it's all going to be okay. So for all the hundreds, and we mean hundreds of people that are with us today, we want to thank you on behalf of AARP, and thank you, Steve Andersson, for always your expertise. And I know you have a very busy schedule, and for putting us in is greatly appreciative. For those of you looking for any resources on caregiving or, financial elder law, you can look to AARP. Just Google aarp.org. It's there. We have breakouts on everything that's happening with Social Security to caregiving. If you are in Illinois, you want more information on aging-specific resources, look to the Department of Aging website at www.ilaging.illinois.gov. Please take advantage of all the resources and the resources that AARP has for virtual. We look forward to seeing you again next month. Sign up so you can get the direct link. Thank you, and everyone have a great day.